have joined so far. So we will start our program. Sir, shall I start?
Time ko thoda.
Sir, program start kar do, sir. Sir. Okay, a very good morning and a warm welcome to all the dignitaries and participants who have joined with us on today's webinar. My name is Ms. Chukuyaka and I will be the host of today's webinar. As you all are aware, we have assembled here to celebrate the end theme of a year-long program of Vigyan Utsav as a part of Azadi Ka Amrit Mahotsav, initiative by Department of Science and Technology, Government of India, to celebrate and commemorate 75th years of progressive India. The 1 month, one team started in the month of September 2022 and conclude in this month of August 2022. So in a modern world, intellectual property rights have significant influence in international and indigenous trade of every nation. With the advent of digitalization, there are chances of creative ideas being copied or duplicated by third parties without her prior permission. The knowledge on intellectual property rights in today's world has immense importance in every field. As the theme of this month is intellectual property right, we are very fortunate to have eminent speaker with us who will be sharing their in-depth knowledge and expertise on multiple aspects of IPR. So welcome you all once again. With this, we begin our program. I invite Dr. Pagbu Lambu. He is a Deputy Director of Arunachal Pradesh State Council for Science and Technology, Government of India, Government of Arunachal Pradesh, to give a welcome address. Sir, please.
First of all, good afternoon to all the participants and welcome to you all in this session of Vigyan Utsav being hosted by Arunachal Pradesh State Council for Science and Technology from Arunachal Pradesh, which supported by Department of Science and Technology, Government of India and Italy. Since the launching of this program by Honorable Union Minister of Science and Technology, Government of India, and the inauguration by the Minister of Science and Technology, Government of Arunachal Pradesh in Arunachal. Arunachal Pradesh is attending for the last 11 months, and this may be the last of this important program. In this, I, on behalf of the Arunachal Pradesh State Council for Science and Technology, Department of Science and Technology, Government of Arunachal Pradesh, place my welcome to respected Dr. Depriya Tattva sir, who is the advisor of Chief Division, Department of Science and Technology, Government of India, Dr. Rashmi Sharma ma'am, scientist, DST, Government of India, Ravikant Prajapati sir, scientist, Department of Science and Technology, Government of India, for their attending in these programs. I take opportunity to take thanks and welcome to Dr. Aruna Tiwari ma'am, Assistant Vice President, Cell for Eye Care Promotion and Management, and also the Director, Department of Promotion Industries and Internet Trade, Ministry of Commerce and Industry, New Delhi, for which is acceptance on our request for one of the research person of today's program. Welcome you, ma'am. I also extend my welcome to Dr. R.K. Burman, who is the former head of S&T divisions and the Nodal Officer for PIC in Assam Science and Technology Environmental Council for their acceptance and participation, and once again, welcome you, sir. I take this privilege to welcome Dr. Sandeep Singh, IPR Coordinator and who is the Associate Professor, Department of Mechanical Engineering, Nerist Itanagar, for their acceptance and participation as one of the resource person for today's program being hosted by us. I also take this opportunity to welcome all the scientists, officers, and officers of my S&T department for their participations. I also welcome and the participants member from State S&T Councils, Science and Technology Department, technical and non-technical institute of the country for their support and cooperation by participation in these important programs. With this, I conclude my welcome speech with the slogan Jai Bharat and Jai Vigyan. Thank you all.
Thank you so much, sir. Okay, so moving to our program, we have our first speaker. May I invite Dr. Aruna Tiwari. She will be presenting a talk on GI and socio-economic impact. She is the Assistant Vice President of Cell for IPR Promotion and Management, and also working for Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, New Delhi. So may I invite Dr. Aruna Tiwari. Please, you may take your time.
Am I audible?
Yes, ma'am. You are audible, ma'am.
Okay, thank you. Thank you, Science and S&T Center, Arunachal, for giving me this opportunity. Earlier, I was working for, I'll just give a short brief about me. I am Dr. Aruna, and I was working as an IPR scientist in DST from 2009 to 2021. And recently, I have joined Cell for IPR Promotion as an Assistant Vice President, which comes under Ministry of Commerce, and it handles all the IP related matters of the country. It's basically nodal agency of IPR matters in the country. So today's topic given by Terpo to me was the overview of geographical indication in India and its social impact. So basically, I don't know why this slide is not moving. Screen sharing. Okay, so basically, general agreement on trade, tariffs and trade was there after Second World War. It was formed as an association of few countries so that tariffs could be managed in different countries while doing the trade. And it had eight negotiations. I'm not able to, okay. Okay, so basically before I come to geographical indication, I just wanted to give a brief why IPR is so important nowadays and why GI is, we are discussing GI. So in its 8th round, GATT became WTO, World Trade Organization, and in one of the World Trade Organization, TRIPS was one of the agreement, and TRIPS talks about IPR, how its member countries would handle IPR matters and how they should handle. So one of the compulsion was to have some act or some regulation in the member countries in respect to geographical indications also. So basically 8 category of IPR is there: patent, new plant variety, geographical indication, trademarks, IC layout design. I'll not go in detail about all these 8 categories. So I'll come directly to how TRIPS has directed us to have some rules and regulation on GI, geographical indications. So it is covered under Article 22 to 24 of the trade related aspect of intellectual property right, that is TRIPS. And Article 21 says indications which identify a good as originating in the territory of a member or a region or locality in that territory where a given quality is essentially attributed to its geographical origin. Basically, a group or association of people who are into the traditionally production of some good, it can be protected through one of the intellectual property forms, and that is known as geographical indications. So we have Geographical Indication Act in place as per the direction of TRIPS agreement. In 1999, we made an act on GI that what should be the provision, how it would be handled, how registration would be in place, and in case of infringement of others' right, how it would be handled, and what would be the punishment and other things. So there are around 87 sections. Among those sections, section 2 deals about geographical indications, what exactly it is. So in geographical indication, there are only 4 types of goods which are considered. One is agricultural, second is naturally produced, third is handicraft or any industry, fourth is food stuff. So in a nutshell, we can define a defined geographical area of production should be associated to this right, known as geographical indication right, and specific production method should be there. A specific quality of the product means a characteristics should be very specific, a name and reputation that differentiate the product from others. So this is what exactly geographical indication is. It is an indication that you have some good which has some geographical territory related to it, and it has specific peculiar quality, and it can be categorized into 4 categories. So first category, some known, very well known GI, we can have Tejpur Lychee, it is from Assam. Gir Kesar mango, the name itself says from where it belongs to. Gir is in Gujarat, Kangra tea is from Himachal, Malabar pepper, it is from Karnataka, Nagpur orange from Maharashtra, Nasik grape again. So these are the example of geographical indication falling in the category of food. Next is handicraft. Madhubani painting is painting which is drawn in the inner wall of a house during the religious ceremonies. So it is one of the geographical indication registered from Madhubani, that is situated at Bihar. Surat Zari craft again from Surat. So you can understand how these geographical indication, registered geographical indication in country relates to that particular region. Kashmir Pashmina from Kashmir, Chanderi fabric, Banarsi sari, Sangeri hand block. Since I have less time, so I am skipping a little fastly. This picture depicts the geographical indication registered under the category of handicraft. Then production, manufacturing. Under manufacturing, these could be examples, few of the examples. Saharanpur woodcraft, Muradabad metal craft from again UP, Mysore sandal, oil and soap from Karnataka, Kannauj perfume, and Feni. Geographical indication is not only given for these 4 categories, it is given for wines and other food products also. So in India, among the category of wines, only Goa Feni is registered, since it is the only liquor which is produced since long in country. So Goa Feni is one of those which is already registered as GI. And in foodstuffs, we can see these registered GI: Tirupati ka laddu, Bikaneri bhujia, Mysore pak. These are all sweet delicacies, Mathura peda. I don't know how many of you have these delicacies. Beyond that, Makrana marble falls in the category of natural products. Natural, when I say natural products, this Makrana marble is used was used in preparing the Taj Mahal, which is situated at Agra. So it is very famous, and it has been used as in the basic ingredient of Taj Mahal. These are few of the examples. Why should we protect GI in India? Because India is a rich storehouse of goods, not even goods. We have a very rich traditional knowledge in every nook and corner of the country, and every nook and corner has its diversity and specificity in terms of food products, handicrafts, and it can be protected through GI. And GI does not gives profit to only an individual. It gives the profit to the proper locality, all the individual associated with this production. The economic potential of these goods is enormous. To prevent GI goods becoming generic, if we'll not register it, someone else would start producing these GI registered items and it would become generic. So to stop becoming a generic item, we need to register GI production in India. Again, agriculture products. India is an agricultural country, and foodstuffs. We have so many variety of foodstuff across the country. So these should be protected through GI. It can improve income of farmers. It retains rural population. Consumers get the details of origin of the product. So these are few benefits. For these reasons, we need to register whatever GI knowledge we have at a different particular region of the country. So benefits, it confers legal protection if someone is producing beyond that particular locality or region. So we can have that infringement suit file on them and get benefit out of it, because of legal protection we could have. Otherwise, unless and until we have GI registration, we cannot have legal protection on it. So it prevents unauthorized use, creates a premium, and so far since the act came into place in 1999, and the first GI was registered as a Darjeeling tea. So Darjeeling tea was the first registered in 2003 or 4. Afterwards, till date, we have more than 400 application filed. Among those 400, only 390 or so is from India, filed by India. And Karnataka state is leading with 42 GI registered in their name. Second is Tamil Nadu, and third is Uttar Pradesh with 34 GI registered in their name. And we have it seems two from Assam, but Arunachal has yet to file any geographical indication, and I'm sure that there must be few traditional knowledge in terms of handicrafts or agricultural products or natural products which could be protected through geographical indication. So now, who could apply for the registration? Again, it has been defined in the Act, only 4 kind of people or group of association can file an application to register any geographical indication in their name. And this is any association of person who are producing those geographical indication related goods, or any producer in terms of when it belongs to any agricultural product, then any producer, group of producer, or any group of organization or the government authority. This is specifically defined that who would file the geographical indication for registration. Only these 4 association or group of people. Beyond these 3, government authority can file that yes, it is being produced in this particular location. So who is registered proprietor? As I defined, that authorized people who are into this production since long or since many generations, they can only use, or they can only apply for geographical indication. Now the terms comes, who is an authorized user? Authorized user is whoever has this geographical indication registered in their name, or anybody else who was not included in the name of group of association, but they are living in that same locality or same region, and they are into that production, because not everybody could be included in one form or so, or not everybody is very aware of their rights. So whoever are aware of their rights, they form an organization and they file the application. But beyond that, many people are also involved in those kind of goods production, so they can become an authorized user. So this facility is provided that they can become an authorized user, if not the authorized producer is being, or authorized owner is being registered by GI registry office. So this I already told. Who can use a registered geographical indication? Anybody who is user, authorized user, or authorized owner. So this is the website where you can file from. Earlier, it was a hectic schedule to send written letter to the CG office, and then handle all the communication between CG office and interior part of country. Now we can file it digitally from sitting at anywhere at Arunachal itself. So you can take help of this website of CG office, and you can file it by your own or your association, or you can take help of any agent who is dealing with GI application on daily basis, or facilitator. There are facilitator also who could facilitate you to complete your application. So this is a website. You can go, you can visit this website and you can have all the details, whatever is required at your end. So particular GI application generally includes what is the product all about, who would be the applicant, which group or which association, list of the people in that association, geographical area of that production. That specific geographical area map is required, and that map has to be included in that application. Proof of origin, since how long this production is being in place. So as an example, if I give an example of Rasgulla, Bengal Rasgulla was filed as a GI registry sometime in 2017, and it got a GI registration. So Odisha was against it. They said, no, we should have this GI in our name rather than West Bengal, because Rasgulla is being prepared in Odisha as well. But they did not provide any historical record, so it was not given to Odisha, it was given to West Bengal, all because of West Bengal produced a historical record that some Naveen Chandra Das was there, who opened one sweet meat shop in 1800 something, and they started selling. Later on, some research scholar received some historical evidence in some scriptures that since 1200 or so, Lord Jagannatha, it is the Rasgulla prepared at Odisha is being offered by to Lord Jagannatha as a bhog. So then it was again filed at GI registry office, and they provided the differentiation, that is the special characteristics of their Rasgulla, that it was not chewy, it was not spongy, it is juicy, and it need not to be chewed, and it can be gulped in one go, and it is little red in color. And while West Bengal Rasgulla is little white and ours is red, so they made a difference. They came up with their special characteristics, and they provided the historical records, and now the Rasgulla is being given to Bangla Rasgulla, a different registration, and Odisha Rasgulla, a different registration. And whoever likes the Bangla Rasgulla, they can demand for that, and whoever likes the Odisha Rasgulla, they can demand for that. Once we get a GI registration, an authentication increase that if it has been GI registered, then it must be an authentic one. So we can have, so the export increases, and in lieu of that, the local employment also increases. So method of production, technical specification, uniqueness, these all things are required in the application to be filed at GI registration. When we file a GI registration, the first filing thing is we have to define the GI, means whatever is required in that GI application, we put it all there in place, and then association name and application in triplicate. It was a practice when hard copy was used. Now that in digital era, we need not to provide any triplicate now. The application shall be signed by the applicant or any agent if agent is filing. Details of specific characteristics I already mentioned. And then when entire thing is complete, we need to file it. Once it is filed and the CG office or GI office feels that there is any deficiency, they provide 1 month of time to come back with all the deficiency details. And if the applicant is providing all the details to the GI office, and with a content of statement of the case that this is the peculiarity and this is the historical records, group of experts check whether the statement is correct or not, is being claimed by that association. Once it is done and it is over, they will ascertain the correctness of particulars, the experts. Thereafter, an examination report would be issued. Once the report is issued, and if there is any objection, then objection meeting time is given to those applicant for 2 months or so. If we are willing to file a response to that objection, we can file, or else we can appeal for hearing. So a hearing is given, and after that hearing, it is provided with GI registration, and it comes in the journal online. So in geographical indication journal, it is published once it is granted. And if there is any opposition, like in Bangla Rasgulla case, there was an opposition by this Odisha government. So opposition can be registered, and within 3 months, this opposition needs to be um, disposed of, though entire period is minimum, not minimum, it's generally defined as 6 months, but practically it takes much more time, though CG office is trying to uh, limit it to 6 months only, so that more and more geographical indications could be filed. So once everything is settled, registration is done, and now the geographical indication users and authorized producers can use it and put that GI, it has been registered as GI, and put that GI logo, which was accepted in 2017. Now renewal, a registration is done. Now renewal fee needs to be paid, and renewal fee has to be paid every 10 years. For every 10 years, we can file a maintenance fee, and beyond that, we can pay it on every 10 years, and we can keep it maintained for as much longer period as we can. So in a nutshell, the filing procedure is given. Filing an application, examination is there, objections, if any, then a hearing is provided, opportunity to hearing is provided. In case of acceptance, it is advertised in the journal. If any opposition comes and opposition is authentic, then it can be refused. Earlier, intellectual property appellate board was there, where we can appeal after refusal. Now appellate board has been dissolved in 2021 April by the government. Government brought an ordinance and dissolved the IPAB. So we have no idea who would handle these refusals now. We need to go to direct high court rather than any appellate board. So after acceptance, the GI is registered and GI certificate is issued. This is the entire process in one nutshell. So what indications are not registerable? Not every indication could be registered. So in our act, it is defined which or what kind of geographical indication cannot be registered. And it says that any deceiving or confusing geographical indication mark, we cannot be registered. Then any scandalous or obscene matter, it cannot be registered. Again, which comprises any religious matter. If we are going to hurt any religious sentiment to a different religion, then it cannot be registered as GI. And beyond that, if any generic name is there that everybody is like roti is being used by everybody, the generic names cannot be used as a geographical indication. Or roti or chawal, we cannot. But specific chawals with specific characteristics we can have geographical indication registered in that locality's name. And false representation, say for example, is Mathura is famous for peda, and I start making Mathura ka peda and preparing peda in Delhi, and I call it as Mathura ka peda, then it will not be granted as a GI. So these are indications that also, if I infringe some registered GI's owner's right, so the maximum from 6 months to 3 years terms of jail, or 50,000 to rupees 2 lakhs can be sanctioned on the person who is infringing the right of any geographical indication owner. Now, duplicate a copy of some geographical indication, if I'm falsely applying geographical indications to some other product, making, disposing, anything wrong, if I'm doing with the registered GI user, knowingly or unknowingly, these points. And in case of infringement, suit can be filed, and it has to be filed before the district court under section 66. It has been defined in our Geographical Indication Act. The registered proprietor or authorized user only can initiate infringement action. I am sitting at Delhi. I cannot file infringement suit for any Assam or Bengal Rasgulla case. So any registered proprietor or authorized user can only initiate any infringement case. How to make this geographical indication thing successful? Because looking at the diversity and richness of our culture in country, geographical indication has potential of becoming successful. So we can create awareness through training like we are doing today, active participation from producers and users, strong marketing or branding, effective legal protection. So beyond that, we can have a beautiful packaging of the material or goods which we are having as a GI registered. And beyond that, government aided fairs can make it popular so that the registered GI could become a popular word term. Then online marketing, e-commerce portal could be used for all these registered GI related products. We can develop database or products. Through the database, the end user can come to know about the stakeholders and place to buy GI registers. So all sort of stakeholders, buyer, producer, seller, and other beneficiary could be brought at one place. And even the infringers, promoters can come to know about the producers, help to create a network between producers, stakeholders, consumers. Monitoring would be easy for of the market situation, collecting. That is all. It seems my time is over. If there is any question or any suggestion, I would be happy to take it. Thank you, everyone. And thank you for giving me this opportunity.
Any question from audience? You may ask now. I think there is no question. Thank you so much, ma'am, for your presentation. It was a crystal clear overview of GI and socio-economic impact. Thank you for providing us the knowledge of why GI protection is necessary and how to file the GI application and their profits in one's life. Thank you so much, ma'am, for your presentation.
Thank you. Thank you.
Now moving to our next speaker, I welcome Dr. R.K. Brahman. He will be presenting a talk on IPR leading to startups. He is a retired head S&T division and nodal officer Patent Information Center. He also worked in Assam's Science, Technology and Environment Council. Sir, over to you.
Yeah. So can you hear me?
Yes, sir.
Yeah. Okay. I'm clear, no? Am I clear to you?
Yes, sir. You are audible, sir.
Yeah, and the slide is there, no? Slide?
Yes.
Yeah, fine. In fact, I am grateful to state as a Patent Information Center, S&T Councillor, Arunachal, for inviting me to be a part of this program. And this is a very important topic. In fact, IPR leading to startups. Last, in fact, my preceding speaker has spoken very beautifully on GI, geographical indications. They're very good. And my topic is IPR leading to startups. And in fact, the topic was given to me by Mr. Ronya, in fact, and it's a very dynamic and challenging topic, I feel. So, in fact, when you say that intellectual property rights leading to startups, in fact, there is a flow, in fact, from intellectual property to the startup. So I thought of putting a little bit of mathematics, in fact. So in calculus, suppose we have two variables and they have a relations, and we call it as they are said to constitute a function. Here, the x is the independent variable and the y is the dependent variable. Now, if you put instead of x the IPR and the y, if we replace the Y by startup, there is a relation between them. So we can say there is a functional relation between these two, say items. And the question is that, how is the relation? That's a very important point. Is the relation between these two, that is, say IPR, say patent, and the startup, is the relation is linear, or it's a non-linear, or it is something exponential? In fact, the relation seems to be a little bit critical and very challenging. Say nowadays, one can go for doing some mathematical model between these two variables, and I think one can predict also. Suppose someone starts an startup with a patent on any device, and I think by making some kind of models, I think they would be able to predict what would be the success rate of this startup. So importance of intellectual property, as you know, as our administrator has said, it's growing day by day. So importance of intellectual property is growing day by day. IP is forming the base of intellectuals, researchers, industry, and the economy. Here, this industry and economy, these two words and the startup are linked up. And the most important part is that, for the simple reason that globally we are getting more and more connected. A long time back, there was not much connection, but now it's so much connected because of say this internet and all this, and a lot of economy, a lot of activities. So it has become very important. Therefore, in this globalized, and now we used to say village like, so we have to be very sensitive to sustain ourselves. Like Charles Darwin, you may be knowing that he talked about the science of evolutions, and he talked that survival of the fittest. In this concept, in the concept of survival of the fittest, that IPR plays a very important role in terms of economy, in terms of growth, which I'll tell you. Most beautiful thing what I have seen is that, most beautiful thing gift to us by nature is that we can think, we can imagine, and we can create. And based on these processes, we have what? Intellectual property. Of course, then followed by rights when the legal systems comes in. What is meant by intellectual property? Intellectual property is the property which has been, I'm not talking about intellectual property right. I'm just talking about what is intellectual property. Intellectual property is a property which has been created by exercise of intellectual faculty. It is the result of person's intellectual activities. Intellectual activities means you may think, of course, idea comes to you, ideas evolve in your mind, and you think, and we apply some kind of resources like fund or material, then we build up something. So it is the result of intellectual activities. Thus, intellectual property refers to creations of mind, brain, such as inventions, design for industrial articles, literary, artistic works, symbols, which are ultimately used in commerce. And the important thing is that IP, intellectual property, it's in the first stage, it is intangible in nature. It's not physical, it is something metaphysical. Now, I come to the intellectual property right. When the legal systems comes in, one is the point of where things have been formed by your intellectual activities. Then once the law gets into it, it becomes your IPR, intellectual property right. IPR is defined as right given to the people over the creations of their minds, the brain. A right usually gives the creator an exclusive right over the use of his or her creations for a certain period of time. The creator in return has to disclose his creations to the authority. That is an important point. Intellectual property rights allow the creator or owners to have the benefits from their works when these are exploited commercially. The question that startup comes in here. Of course, IPR, as said, a poet also can have this IP right. An engineer also can have an IPR right. A farmer also can have an IPR right. A businessman can have an IPR right, like a trademark. An electronic engineer also else makes a new circuit design layout for a system, he can have an IPR right. a reputed product of a community, it leads to IPR. That our earlier speaker has said about geographical indications. A community or a place can have a IPR right in the form of GI. Of course, I think in the slide, what Madam has said is that Assam, I have seen it is not 2, I think it should be 10. Little bit of correction should be, probably there should be correction. In the slide, it's shown which states has the highest number of those distributions of GIs. In the slide, I think it is slightly shifted. I think Assam, I think it should be 10. A scientist develops a new molecule of a drug, it leads to IPR, intellectual property right. Now, as said earlier, I just spoke in a generic form now. Patent is a class of IPR which we have got in our country. Industrial design, we have a IPR, is a kind of IPR right. Layout design of integrated circuit, protection of plant varieties and farmers' right. A farmer can have, or a seed breeder can also have this right. Geographical indication, as said, the community can have this right, which talk of the origin of the quality and the originations of a place with repudiations, that geographical indications. Copyright is known to all. Trademark, which is used in the business, protection of undisclosed information and trade secret. This is a little bit of, it comes under civil laws. Now, all these IPR rights are backed by some kind of act which have been enacted in the parliament. Now, I think we have got very updated acts. Like patent, we have this Patent Act 1970 Amendment 2005. There are a lot of amendments are going on to keep the act in sensitive mood. We have all, for this, all kinds of IPR rights, we have an act behind that. Based on this act, we have the rules and regulations. And these rules and regulations, as our earlier madam has said, how to file a GI, the rules and regulations are prescribed. And as per that, we need to file. Or if you want to have a GI right, we have to file as per that rules and regulations. That is a point. Now, what is the aim of the IPS systems of a country? It accelerates the growth of science and technology, which is known. Promotion of innovations, it helps people to innovate, encourages people to innovate. National development concept is there. Active partner in global trade. Enhanced educational level, because in the school, if we help students to think and do something of their own, and this is being encouraged by IPS systems only. So it helps in improving our educational level also. Better utilization of natural resources, human, biodiversity, mineral, etc. For example, let us, in this point, let us talk about the GI of Assam, the Mugda silk of Assam. Initially, it was not organized, but now this has been, a GI has been filed and GI has been registered on this in 2006. Now, because we have the registered proprietors, now the registered proprietors and registered users, they form some kind of union, that they keep an eye on this. So there is some kind of regulations in the systems. So it helps in regulating, in preserving, in conserving bioresources also. Better living standards. Why create IPR? Satisfy human intellectual urge. Let us talk about the great innovator, Tesla, in fact. That urge to create something in him was so strong. He has created a lot of things, in fact. That urge, not only in Tesla, it may come to anyone, any student or any researchers, any faculty. There is an urge. Sometimes the urge is there. We need to satisfy that urge. That is one reason. Now, business reason is there. When a startup comes in, a lot of business will be there. Therefore, the IP systems will help him to do business, which I'll tell you later. Make research more need-driven, easy technology transfer, attract collaborations, attract funding agency. So if a startup has a patent, if a startup begins with a patent, in fact, so it is qualified. So it is something unique at global level. So people will have more confidence in him. So venture capital or some other capitals may come in. There are strategic reasons, and capturing new knowledge area, image building. Why protect? Survival of the fittest, the inner order of nature. If you do not protect, someone else will do. A lot of things are going on. A lot of things happen in this line, in fact. Especially I've seen in the all conventional companies and startup. The big conventional companies always have the tendency to in fact not kill exactly, has a tendency to liquefy the startup. Those things comes in. Develop a culture of protecting your inventions. We should try to develop the culture of protecting your invention. Business, national, international, strategic again, promotion to build, and the most important thing is to build knowledge economy. Again, if you look at the present global systems, in fact, the economy is no more conventional. It is very, it is based on sensitivity, in fact. So that knowledge has started playing a very big role now. So these are important, and these are being encouraged by IPS system. Possible ways: build system support to boost human creativity, like say Arunachal is a TIC. In Arunachal, I have seen, and I've been in touch with them also. They have been helping students, even college teachers, even faculties from research institute to be more aware on IPR systems and to file more and more say patent or GIs. So this is important point. Invent, innovate, develop, and launch new products and processes. This is the part again. Startup comes in. Launch your own company. Take a lead in the market. Easy licensing, technology transfer, commercial further R&D, collaborative R&D. Possible ways: competition challenges, sustainability, long-term business image, enhance market value, raising fund, maximize profit, partnership, attract collaborations, and joint ventures. Nature of intellectual property rights. So when I say about nature of intellectual property rights in context of our own country, I'm talking about those 7 classes: patent, IPR, patent, GI, and all those 7 classes. IPR rights are basically monopolistic right, in fact, negative rights, in the sense that if someone gets a patent on some kind of device or some kind of process, he excludes others from using those things or selling without his permission. That's the point. So it's a monopolistic right, of course, for a certain period of time only. In case of patent, it is a period of 20 years only. IPR have fixed term except trademark and geographical indications which have indefinite life, provided these are renewed after stipulated time under the law by the official fees. Like as Madam earlier speaker, Madam has said about the GI. The GI, after 10 years, one needs to review, and one can keep on reviewing till the existence of the probably art. That's the point. So one has to review, one has to renew, otherwise it will be struck out from the registry. IPR have to be renewed from time to time for keeping them in force, except in case of copyright and trade secrets. Patent also, you see, you have to be, of course, there is up to 20 years, there are steps where you need to renew it. Nature of intellectual property rights. IPR are largely territorial rights except copyright, which is a global right. So if you have an IPR right, say in a patent in our country, in India, the right prevails only in India. IPR can be assigned, gifted, sold, and licensed like any other property. So if you have a patent, it's just like a piece of land or car. You can assign, you can gift, sold, and license like any other property. IPR usually entails, of course, this is a very important point. IPR, I have seen any class, of course, it is strongest in the form of patent. In the case of patent, always has, usually entails new and original knowledge. Anything that is in public domain, that doesn't come under IPR. This is perhaps the only right which can be simultaneously enjoyed in more than one country. All IPR apply to new and original knowledge and not to what is already known, mainly old knowledge. Public domain knowledge cannot be protected, patented, unless modified and improved. This is a very important point. So any knowledge, of course, it may be in public. So if you want to have then if you can work on that, and you can have to have a change with respect to the prior article in a much bigger, that comes under that the concept of, if you look into the patent, that basically novelty, non-obviousness, and industrial application, that non-obviousness part is very critical. That is the point. Now, there are so many, of course, we have almost 7 classes of IPR in our country. But in terms of startup, of course, one can start a startup on plant varieties and protection right also. But let me talk on patent, some aspects of patent. The patent, many of you who have participated might be knowing or may have patent also. A new product or process involving novelty, inventiveness, and capable of industrial applications. The most beautiful part which I like is that that novelty, inventiveness, and capable of industrial application. Novelty is something new with respect to prior art and with global reference. That is very critical. So someone has a patent. In fact, we can claim that I have something in my hand which doesn't exist globally. That's a point. Inventiveness, that is that non-obviousness, but it has to have technical, there may be some change with respect to the prior art. The depth of change has to be much appreciable. That is a point. And capable of industrial applications in the sense that it should be industrially producible. And suppose if I make something and only I can make it, no other one cannot, no other people can make it, then it doesn't have industrial applications. That is the point. It refers to technical solutions to a technical problem. It may be an innovative idea or maybe in the form of a working model or prototype. It should not be used, published, or claimed in any document in the country or elsewhere in the world before the date of filing of the patent applications. That is obvious. Now, conditions for patentable inventions. Now, novelty, as I have said, it is new. Patent charge has to be done, has to be seen, has to be established so that it is new. Inventiveness, non-obviousness, and it should not be apparent, in fact. It should not be apparent. That is the point. And there are some conditions by which this point is checked. Industrial application, as I have already said. The question is that patent is a government-given right to the inventor to prevent others from making, using, manufacture, and market the inventions for 20 years. It is a property right, can be gifted, inherited, as I have said, assigned, sold, and licensed. Now, if you look at the mobile phone, necessity is the mother of invention, in fact. So Martin Cooper, of course, he was the man who has invented this mobile phone. So earlier with the Graham Bell, the telephone was always had a wire. So it was difficult to move from one place to other place. So he was a man who thought that, can we make something without a wire? And this has led to this mobile telephone. And based on his inventions, many startups came up. Of course, many could not last also, but some lasted. That's the point. Now, what I want going to say is that based on a patent, there may come startup, may come many startups, but out of these, only 2 or 3 may persist. Others may not be able to succeed. That's the point. Now, this let me share, since I was in PIC and found the patent which was granted recently, I think it was in 20, and this was done by one professor, Foucault. He did some, he has built up, he has newly made some kind of catalyst. His catalyst increased the rate of CN and CS bond forming reactions, specifically Sand-Lamb coupling at room temperature in shorter time than the ways currently followed in the world. That's the point, catch point, in fact. He has made something which has depth and better than the existing one. So therefore, of course, he got a patent. And based on this patent, based on this quality itself, so there may be demand in the market itself. He has a manufacturing process. So based on this itself, one can start a startup. Well, of course, Professor Foucault may not go for doing a startup because his line is different. Doing business is little different. Of course, if he becomes more enterprising and if he leaves his job and start a startup, that won't be a different case. Now, this is again a very recent one, and what I say is that this is a patent number, and of course, granted to one Manoj Das Hajo, invented bamboo reinforced cement concrete using constructions of beam and columns of civil structures using bamboo as primary reinforcement. Of course, 40% less cost. This also got a patent. I have seen, of course, I was also involved with this. already 2-3 demonstration houses have been made based on this. It lasts because it is trying to reduce the use of MS mild steel by using bamboo and some his own scale technique, and that technique has been granted a patent. That's the point. Similarly, this is again, of course, this came in 21-22. The same thing. This is a little different, but his technique has been granted a patent recently. And this is another from Bornalit Fukon Guwahati. Of course, this is a very recent 21-22. Gravity and buoyancy actuated reciprocating power generating system use electricity generator in open channel water bodies like rivulets, rivers, and streams. He also got this patent. You can see the design. Of course, if someone wants to do he himself can start a startup on this, or he can do licensing, and someone interested, he can start a startup on this. That's the point which I want to show. Very recent one. The other man is patented Ranjit Salia Galaghat invention Naga King. So of course Naga King Silly, of course Naga King, that also has a GI. Naga King Silly dryer. We use efficient Naga King Silly dryer with movable draft. Of course, this is being already he has started his startup. He is doing business. In fact, these are being sold now. Very effective one. There's a point. Of course, his startup is not like a startup from DRDO ISRO, but at a certain level, it's a startup having all the qualities and doing good work. Of course, this is another, of course, this is very interesting. In fact, this is a patent recently got it 21-22 done by PACS-T, and this is Dharmananda Bormudoi. Of course, this is a water filter sediment return ground-based multi-stage water leak filter. Used sediments of filtrations are returned back to the ground below the fertile layer of the soil, but above the water level. That is also done. Of course, this has possibilities. No startup has been built on this pattern. In fact, that I'd like to share with you. Now, valuation of a patent. If you have, of course, IPR patent is a form of IPR. It's maybe a device, it may be a process. So it has value. What are the parameters on which it values? A patent's residual life, patent's potential for commercialization. That is important. Startup, patent's potential for commercializations. Here from the springs of this startup concept, patent citation is there. Just like a professor publishing a paper, how much citations, more the citations, more its value. Patents claims are again important because these are critical points where the life of the patent exists. Span of protections of the invention, that is the important point. Competition for the patent, more the competition for a certain patent, it means it has a high value for starting a startup. So if you have a patent, in fact, what will be cost? That is the point exactly. One is the cost-based method. There are experts who can now decide this. There is a method called cost-based methodology, market-based methodology, income-based methodology. Cost-based, suppose you have a patent. So what will be the cost if you want to sell this patent to someone else? You want to license this patent to someone else, then you need to understand the value of your patent. So there is one process that is cost-based. How much you've invested, mental, physical, and all this thing. Based on that, you need to make an assessment. That becomes your cost-based methodology for understanding the value of a patent. Market-based methodology, of course, there are experts who can help if someone wants to assess their patents. Income-based methodology, this is again interesting. Of course, this talks about the future. How much this patent will earn in future. And that is little bit future logistic, and it needs deeper understanding of the marketing trend. Commercialization. Suppose the owner of an invention has the following options to commercialize his or her inventions. Manufacturing and marketing of the product by himself. Suppose if I have a patent, if I am a scientist, I have a patent, I want to do business. So I can go for doing manufacturing or marketing of that. It means I have started a startup. That is the point. To give license to someone to manufacture his product, he can give license to someone businessman, he can do a startup on that based on this licensing. Or to sell the patent right, someone if interested, he don't want to have this patent anymore, he can sell it to someone that's who sells, and he can start a startup based on that. Now, Startup. A startup is a company, I think you've been knowing it is a very important word now. Our country also having, almost everybody knows about startup, and it is good that our country is moving very, have a very positive trend in the startup. And, it is, but USA, China, they are much advanced. But India also coming up very strong in the startup business and startup ventures. A startup is a company in the first stage of its operations, means it is being born. Startups are founded by one or more entrepreneurs who want to develop a product or service for which they believe there is a demand. So it is again the demand driven. One is to read someone entrepreneur, he reads, okay, now owners or some say universal something is coming up. He sees that there is a very good market for this, or people needs it. So based on that, he can build up a startup. Of course, calculated risk is involved in a startup because it is seen that, of course, I have seen one report for IBM which said in India, almost more than 90% startup are in fact don't sustain after 2 to 4 years. So calculated risk is involved. Startups wants to grow with the goal of disrupting the market. That's the critical part. Startup wants to grow with the goal of disrupting. What's the disrupting market? Suppose in the market something is going on, people is buying. So he wants to launch something which immediately people buy, and the earlier one is not being bought. That's the point. He wants to build a new line of attack. Like for example, say once upon a time we had a camera. In the camera we had a reel. In the reel we used to take photographs, and the reel after that we used to wash and give it to the studio. They take time. Of course, that is a one point of say technology-based commercial activities based on a reel. But when CCD came in, search couple device came in. Now we have this camera based on search couple device. It's so easy. So that now this camera real concept has gone. So the day it was started camera with CCD, so this was a point of disrupting technology. It means it has brought a new line of marketing or new line of business. That's the point. A startup is no older than 3 to 5 years. After that it becomes a normalized business system using an innovative disruptive business model or technology targets a significant revenue and staff growth, thriving in a high-risk environment. It's a risky way because, as seen, I have seen the IBM's report says that almost more than 90% startup in our country doesn't last long. In fact, that's a very critical. So it is the urge to create something and urge to do some kind of entrepreneurial activities, in fact, give birth to startup. And if the startup is based on some kind of, say, patent or some kind of IP, that becomes good, which I'll tell you later in the next slide. Startup and commercial aspect. The commercial aspect is a critical challenge to a startup. A competitive market demands a product, services to be well usable, functional. It is to be desirable, aesthetic. It is to be durable, sustainable, affordable, cost-effective, and above all, there need to be feel-good factor, which in totality ensures a buyer the value for his money. So these are some of the parameters for a successful startup. IPR is a base for startup. IPR can be unique selling propositions of the product or service in today's competitive and dynamic world. IPR helps create a sustainable and defensible differentiator for the startup. IPR creates a high entry barrier and helps startup to grow faster with respect to its competitors. Means it builds up some. So once you have IP right, say patent, then that it gives you some kind of extra support to grow faster, so that competitors cannot come and take your what is called creativity. That is a point. So it's a very important. It builds up a seed in favor of your business, in favor of your venture. IPR creates high value of the startup and thereby more trust and confidence among the investors of the startup. If you look at a startup, basically the man who starts, the because he is not rich. In fact, he may be rich also, but he has to build up money. So once you start something on an IPR-based startup, and so once you say no, people has a pet knock, then more investment is likely to come. That's the point which I'd like to say. Now, let us look at this point, very simple, which I want to show. When you go for doing startup, it is not that it's a very big thing. Sometimes small things also one can start a startup. Now, if you look at this safety pin, it was invented by Walter Hunt long back. If you see the patent date, very long back it was invented. Of course, he had some problems, money problem. He wanted to, so he was a mechanic. He was creative. So ultimately, he has created this safety pin, and he got a patent also. So after being issued US patent number is on April 1849, mind that 1849 he got it. So he sold the patent to W.R. Grace and Company, this amount and all that. He got some money. From this money, he has liquefied his debt and all that. Now, most important, but what Hunt failed to realize is that the years to follow, that company W.R. Grace and Company would make millions of dollars in profit from his invention. That's the point. The point is that the man he has invented, and he got very little, but he got the patent, he sold it to somebody, the company who are expert in doing business, they earn a lot of money. There's a point. So if you invent something, and if you're interested in doing business, you can go for a startup. That is the point. Of course, you should have this IP right also on that, so that it builds up a protections for you. Because initially, since you are born, a startup is being born, there are a lot of problems maybe there. So if you have some extra advantage, through the IPS systems, the success rate may be higher. That's the point. So a success of a startup, there are many factors which would decide the growth and sustainability of a startup. However, IPR is one of the most important factors. And with this slide, I would like to thank you for listening to my talk. Thank you.
Thank you so much, sir, for giving a comprehensive insight on IPR and about startup. Thank you so much, sir, for your presentation. Any question from audience? You may ask now. I think there is no question, sir.
Yeah. No, because time is.
Yes, sir. Thank you so much, sir.
Yeah, thank you.
Okay, so let's move to our third speaker and the last speaker of today's webinar. I welcome Dr. Sandeep Singh. He will be sharing words on IP laws. He is a coordinator of IPR cell of NAREST and also associate professor in Department of Mechanical Engineering, NAREST. I welcome Dr. Sandeep Singh. Please, you may take your time.
Thank you, madam.
Thanks.
Good afternoon, everyone. Burman, sir. Namaskar.
So you're fine?
Yes, sir.
You're fine.
With your blessings. I'm fine, sir.
Very nice, very nice.
I hope my screen is visible.
Yes, sir. It's visible.
Okay. In fact, the topic for the presentation is patent laws, 1970. But the very first slide that you'll see, it is named as the Great Indian Pencil Tamasha. At the end of the presentation, I'll tell you as to why this Great Indian Pencil Tamasha, that has been kept as the first slide. But before I proceed, Please look at the prices that has been quoted. Uniball Kurutoga mechanical pencil. In India, they are charging almost 1,000 rupees for one piece. But the claim is it costs nearly 2,000. That is the claim. I don't know what exactly the price is. Likewise, Sakura cushioning point mechanical pencil. They are charging 180 rupees for a single piece. Whereas a Faber-Castell soft grip mechanical pencil, not one, two in number, that will be available for 40 rupees. And the Natraz fluoro pencil pack of 100, it will cost you nearly 500, which means practically one single pencil costs 5 rupees on. Keep in mind, there is something on sale which is worth 1,000 rupees, another one approximately 200, yet another one 20 rupees, and finally the last one which is for 5 rupees each. And all these are just pencils. I'll speak about Indian Patent Act 1970, which has an attachment that is the patent rules of 1972. I'm Sandeep Singh, Associate Professor in Department of Mechanical Engineering, NERIST, and closely associated with IPR activities in close collaboration with the team led by Mr. Terpuronia and Arunachal Science Center. Let's take a look what exactly the intellectual property that means. In fact, Berman sir has explained quite a bit of it. Much of details will not be required, but since I was unaware as to what Berman sir will cover, so it has remained. Intellectual property is a product or creation of mind. What it means is it cannot be physically touched, it cannot be felt, it cannot be stored somewhere. So it's different from other properties in terms that it is intangible. Now, since it is intangible, so the way we protect our valuables by keeping it in a chest, or we protect our cash money by keeping it in a bank, we obviously need to have a way as to how the intangible thing that can be protected. And obviously, there should be a very different way for protecting such property which is intangible. Practically, when we speak of IPR, that is intellectual property rights, those rights, they are practically a body of law developed to protect the creative people who have disclosed their invention for the benefit of mankind. This protects their invention from being copied or imitated without their consent. This consent may be required for multiple purposes. One of the basic purposes for which the consent is required is for making money, which, as Berman sir has said, is the basis for startups. Now, I'll very quickly move on to the laws which are related to Indian patents. It is governed by Indian Patent Act, that is Indian Patent Act of 1970, and rules 1972. Subsequently, there has been an amendment, that is Patent Amendment Act of 2005. As you'll see, that majority of acts which are enacted by our parliament, they will have a small rider. It says that it will be operated all over India, other than this part of Jammu and Kashmir, this part of Sikkim, this part of Nagaland, etc., etc. But somehow, the Patent Act of 1972 with Patent Amendment Act of 2005, it doesn't have any rider like that. The patent granted under this act is operative in whole of India. So whatever is our geographical description of our country, this act, it prevails all over that. There is no exception. Historically, it derives from the Patent Law of 1856 and Patent and Design Act of 1911. But in fact, the 2005 amendment that has been placed or that has been enacted so that our Patent Act is in line with the WIPO requirements. Let's try to understand what a patent is and what exactly is the purpose of getting a patent, why somebody should strive to get one. Now, let me first start with an example. Say, I crack a joke in group of my friends. And next evening, one of my friends, he tries to crack the same joke and tries to amuse the friends in the group. Obviously, I'll say that, look, buddy, you're trying to crack my joke. That was mine. This is exactly what is the concept of patent. You have something, you need to have an authentication that yes, that belongs to you. So a patent is a grant from the government. So government is the agency which certifies that yes, this particular thing, this particular property, the intellectual property, it belongs to Mr. X. Now, what does the patent, grant of patent mean to the particular person? It confers on the grantee, the person to whom it is granted, for a limited period of time, the exclusive privilege of making, selling, using the invention for which the patent has been granted. So say, I claim that this is my joke. So only I will crack that joke on the screen and I'll collect money on my YouTube channel by cracking that joke. Somebody else cannot do it if it is patented on me. To enjoy the exclusive right over the invention. This exclusivity means only the person who has been granted the patent, only he has all the rights over the invention. And it also excludes others from imitating or copying it. But what may be the purpose? The basic purpose is the patent is to ensure commercial returns to the inventor for the time and money spent in generating a new product. Now let's come to the most important point. What all can be patented? I forgot to tell you this thing that these slides, they have been prepared based on the Patent Act of 1970 and the Amendment Act of 2005. So practically when I say the patent laws, these are precisely what is available there. I'm just trying to present it in simple language. So if you try to look at the list, what all can be patented? Fundamental requirement in order to be patentable, the invention must pass 4 tests. The first test is the invention must fall into one of the 5 statutory classes. Either it should be a process, or it should be a machine, or it should manufacture compositions of matter, or it may be a new use of any of the above 4. That means the process, machine, a manufacturing method, or a composition of matter, or any combination of that. Also, to be patentable, it's very important that the invention must be useful. Say a very complicated but worthless thing, not patentable. The invention must be novel. After a while, I'll come across this particular term, what novel means, and the invention also must be non-obvious. So if these 4 parameters are satisfied in the particular thing which is being attempted to be patented, probably a patent will be granted. So it should be either a process, it should be a machine, or it may be a manufacturing process, or it may be a composition of matter, or it may be a combination of these 4. It should be useful, it should be novel, and it should be non-obvious. Something which is known to everyone. I cannot pretend to be very smart and say that, look, I want to patent it. No, it is known to everyone. I cannot patent it. Now let's take a look at some of the important features of the patent law. The Indian patent law, it permits patenting of both the product and the processes. generally, the term of patent is 20 years. That means the patent is granted for 20 years. After that, it will go to public domain. Examination of patent request, that is generally done on request. Both pre-grant and post-grant opposition are possible. That means when examination has been completed, it may be that the examiner may place certain opposition. He may say that it is not very novel, it is not unique, so patent cannot be granted. Or it may be other way around as well. The patent has been granted, but still somebody believes that it is just a copy. So a post-grant opposition also is possible as per Indian patent law. There is generally a fast-track mechanism for disposal of appeals. Generally, after 3 months, after 6 months, that type of situation will not arise. An appeal is made, it will be disposed of very quickly. There is a provision for protection of biodiversity and traditional knowledge. This is very important for us to understand. If there is a general class application, publication of application after 18 months will be made. But if an expedited early publication is required, that also is possible. Generally, a patent from the time of its application to its grant, in general, it will take 2.5 to 3 years. But there are means and ways how it can be substantially reduced. So there is an option or a facility of substantially reduced timelines. A span as small as, say, 8 to 9 months will be sufficient to get a particular invention patented in India, and for that matter, in any other country. There are many safeguards in the patent law. The first is compulsory license to ensure availability of drugs at reasonable prices. There is a provision to deal with public health emergency, and there is also a provision of revocation of patent in public interest and also on security considerations. I'll not like to get deeper into this, but I'll only speak something about provisions to deal with public health emergency and ensuring that drugs are available at reasonable prices. During the COVID period, you might have observed that almost the prices of all medical supplies, it had shot up. And majority of vaccine manufacturers, they had quoted very high prices to Government of India. But even if they claim that ours is a patented product, we cannot give you without charging our own money or cut on that. Government of India, by virtue of the patent law, it holds the right with itself that it can insist that your patent for the particular drug, we are revoking it and will distribute that information, how that particular vaccine is to be made, to other companies in public interest. Practically, this was not done. It was not done. But there is a provision that if need arises, it is possible to do that. So basically, the patent law, it is a safeguard to common people that the drug manufacturers or people who handle the health emergencies or people who handle our security, they cannot be simply taken to task by simply quoting that what we have is patented. Government has the authority to revoke that patent. Now let's take a look at type of patents as per classification given in the Patent Act. It may be either an ordinary patent, a patent of addition, or a patent of convention. A second way of classification is also possible. The patent may be related to a product or to a process, and accordingly it will be called as a product patent or a process patent. Now let's take a look at what are patentable inventions. If there is a claim that this is the invention and I want to patent it, the invention must relate to a process, or it must relate to a product, or it may relate to both. It must be new, that is novel. If you remember, a few slides back, I had said that for patentability, being novel is one of the requirements. Novel essentially means it should be new, it should not be a copy. And it must involve an inventive step. Something which is very obvious, it happens every day, we observe it every day, it cannot be patented. There must be one inventive step. That means something new has been added to it. That is the inventive step. And it must be capable of industrial application. Saying industrial application, it means either it should be used inside an industry or it should be produced in an industry. So other way around, if you have a very bright idea, but if that idea can never be converted to a product or to a process, it means it fails the test of industrial application. So essentially that will not be patentable. So for that anything to be patentable, it is very important that it must have an industrial application. There is a added rider. The invention should not fall under Section 3 and Section 4. These are a bit lengthy sections. I'll elaborate on that. First, let's take a look on Section 3. It will come later. Meaning of terms in context of patents. Like I had said, new and novel. To be new or to be novel, the invention must not be published in India or elsewhere. It should not be in prior public knowledge or prior public use within India. And it should not have been claimed before in any specification in India. In fact, this particular requirement of new or being novel, this needs to be taken care of very seriously by academic people, because they have a habit or a pressure of getting anything and everything what comes to their knowledge for publication. If something is published, either spoken of in a conference, published in a journal, then patenting that will be as good as impossible, because it has already been shared with people and everyone knows it. So to keep the novelty and the newness, publication in a hurry, it must be avoided. There also was a term of inventive step. It means a feature of an invention that involves technical advance as compared to the existing knowledge. So if something new is getting added to something which is already existing, that is an inventive step, and that inventive step is essentially patentable. And industrial application, it means capable of being made or being used in any kind of industry. Now coming to Section 3. If you remember, Section 3, that lists the conditions where the patent will not be granted. So if there is an invention which is contrary to the well-established laws of nature, however strong the arguments are presented, however good a machine is shown to the examiner, it will not get a patent certificate, because since it is contrary to the well-established laws of nature, practical existence of such a device is really a false proposition. It can never happen. So if you come across a 100% efficient machine, be sure somebody can claim to have manufactured, but it cannot be patented anywhere. Likewise, there will be wall decorations which claim to be making water flow through the lips of a toad perpetually. Such a thing can never be patented. But if it has an assistance of a battery or something, it may. So if anything is in contradiction to established laws of nature, it is not patented. Second, that is Section 3B. commercial exploitation or primary use of the invention, which is contrary to the public order or morality. This also will not be patented. To cite an example, at least I'm compelled to watch that TV show very regularly. Name of that TV show is Phineas and Ferb. And there is one character with name Dr. Doofenshmirtz. Almost in every episode, Professor Doofenshmirtz, he comes out with one or the other innator, which is used for multiple purposes, to the extent how to harass the enemies of him, how to punish the animals which had once harassed this particular professor, so on and so forth. All these things, they are meant to disturb the public order or morality. So obviously, none of the inventions of Dr. Doofenshmirtz is patentable. This is on the lighter side. Or say, if causes serious prejudice to health of human, animal, plant life, or to the environment. Those type of inventions also will not be patentable. There is yet another rider. Inventions falling within Section 21 of the Atomic Energy Act of 1962 are also not patentable. What it means is any of the compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and few more notified by the central government from time to time, they will not be patentable. The Patent Act does not give any exclusion. It does not include this inclusion, but this is a particular situation where a different act, the Atomic Energy Act of 1962, that prohibits the Patents Act to grant a patent to anything which is related to atomic energy. Now let's take a look as to for how long the patent is valid and when the patent will expire. Generally, the patent is issued for 20 years. It's not generally, it's a known fact. It is a established fact. But this 20 years of period, it is with a condition that every year it will be renewed. So if there are other conditions, other situations, there may be an expiry of the patent. That means the grant which has been made to a particular patentee, that patent, it may be placed in public domain. A patent can expire in the following ways. The patent has lived its full term. That means the patentee, he managed to safeguard his patent for all 20 years by all means. That is either by asserting his rights to opposition, or there was no opposition to all, and he has maintained it by making payment of the renewal fees every year. So the patent has lived its full term. After that, it will expire. Expiry means it will go to public domain. Or the patentee has failed to pay the renewal fee. Say this year the patent is granted. After 365 days, I have forgotten to renew the patent. So it will expire and it will be sent to public domain. Or validity of the patent has been successfully challenged by an opponent by filing an opposition, either with the patent office or with the courts. That is what I had said, that if you're able to maintain it for all 20 years by successfully challenging the opposition given by others, or there was no challenge at all. So in case there is a challenge and the challenger is successful, either with the patent office or at the court, then the patent will go to public domain. Or maybe if the challenger is saying that it is his patent or his idea, it won't go to the public domain, but the credit of the present patentee, that will be taken out. Or as soon as the patent expires, it passes to the general public domain And now anybody can use it without the permission of the original inventor. In fact, there is a big ethical and moral issue why after 20 years the patent goes to public domain. But since we are just looking at the patent law, I'll not get into the depths of why it goes to public domain. Now let's take a look at some other aspects. What all rights the patentee gets? The first is right to exploit the patent. That means making a benefit out of the patent. That is the first right that the patentee gets. The patentee has the right to prevent third parties from exploiting the patented invention. At this point, I'll just like to put something on a very lighter side. Generally, we say third party, but we mean second party. So if I'm the patentee, everyone else who is trying to compete for that particular product which has been patented, they're all the second persons. But in legal terms, they're called the third parties. I don't know why they're called third parties. Why not second parties? Anyhow, and the patentee also gets the right to grant license. If he wants to sell a part of his patent, he can assign rights or he can grant a license, maybe as a barter or in lieu of money. He also has a right to surrender. Patentee is given the right to surrender the patent by giving notice in prescribed manner to the controller of patents. So if somebody feels that this patent what I have got, it is just a burden on me, or he wants to dispose it off, he doesn't want to be associated with that patented product anymore, he has all the rights to give this in writing to the controller of patents and he can surrender it. And the most important is right to sue for infringement. If the patentee believes that someone has unscrupulously copied his patent, he has all the rights to institute proceedings for infringement of the patent, and this initiates in a district court. Having said that, I believe all the salient points of the Patent Act of 1970 with the patent rules of 1972 and majority of points which is of importance to common people to understand, that has been covered. I believe I should conclude and thank you. I welcome questions if there are any.
It's a request to all the participants. If you have any queries regarding the presentation, you may ask now. Sir, I think there is no question. So thank you so much for your presentation and sharing your time with us, sir. So with last speaker, we come to very close to end our session. I invite Sri Tarporonia, Scientist B. He is a pattern information. He is in charge of Information Center. It is the Council for Science and Technology to deliver a vote of thanks. Sir.
Am I audible?
Yes, Roneji, you're audible.
Am I audible?
Yes, sir.
Okay. It's a great honor to propose vote of thanks. On behalf of Arunachal Pradesh State Council for Science and Technology, I would like to thank our distinguished speakers, Dr. R.K. Burman, former head Science and Technology Division and Nodal Officer, PIC, Aztec, and Dr. Aruna Tiwari, ABC, CIPAM, Department for Promotion and Industry and Internal Trade, Ministry of Commerce and Industry, New Delhi, and Dr. Sandeep Singh, sir, IPR Coordinator and Associate Professor, Department of Mechanical Engineering, NERIS, for the presentation and making this program a successful one. On behalf of Arunachal Pradesh State Council for Science and Technology, I would like to thank all the participants for participation in this Vigyan Utsav program. Last, not the least, I would like to thank all my colleagues and staffs that have made this program a grand success. Thank you. Bye-bye.
Thank you, sir. Once again, I want to thank you, all the dignitaries and participants who have joined on today's webinar. So we conclude our session here.
Thank you.
Sir, yes.
Thank you.
Have a good evening to all, sir.
Thank you.